A potential case study: Florence Airport and investment arbitrations. This video illustrates how investors may benefit from certain special rights they may enjoy when investing in a foreign country. These special rights can be found either in international treaties, referred to as bilateral or multilateral investment treaties, or national legislations, and are meant to attract and protect foreign investments. When the country receiving the foreign investment, the so-called host country, adopts measures that negatively affect the foreign investment, the foreign owners of that investment may avail themselves of the protection of these special rights by initiating an international arbitration directly against the government of the host country. In these international arbitrations, named investment arbitrations, the investor may seek monetary compensation, specific performance, or reach an agreement with the host country. To show how the mechanism of investment arbitrations work in practice, this video takes as a potential case study the airport of Florence that is owned by foreign investors and whose expansion has been heavily hindered by measures attributable to the host country, Italy. Introduction. The final ruling issued in February 2020 from Italy's highest administrative court rejecting once and for all the expansion of Florence Airport's runway, and accordingly, hindering the growth of its passenger flow as well as its revenue, may prepare the ground for an investment arbitration between Argentinian and Emirati investors, on one hand, and Italy on the other. Factual background. In 2009, the back-then mayor of Florence, Mr. Matteo Renzi, future Italian Prime Minister, proposed the idea of building a runway of 2,400 meters and a new terminal for the Florence airport with the view of increasing its passenger flow. That idea met the support of the region of Tuscany and the Argentinian tycoon, Mr. Eduardo Yernikian, the majority shareholder of Corporación América Airports, the world's leading company in owning and operating airports. In 2014, Corporación América acquired the majority ownership of Florence Airport in order to present the 2014 to 2029 master plan to expand the airport. The master plan aimed at doubling up the passenger flow of the airport and, accordingly, its revenue. The authorization process for the work started in 2015. In December 2017, the decree law containing a favorable environmental impact assessment for the project, the EIA decree law, was issued by the Ministry of Environment. In March 2018, 7 municipalities adjacent to the city of Florence challenged the EIA decree law before the Regional Administrative Court of Tuscany in order to block the project. In the meantime, in July 2018, Corporación América sold 25% of its participation in Toscana Aeroporti S.A.P.A., the local company set up to run both Florence and Pisa airports, to Matar Holdings 2 B.V., a company directly controlled by the Investment Corporation of Dubai, the sovereign wealth fund of the Emirate of Dubai. In February 2019, the decision-making body of the Conference of Services acknowledged that all the competent administrations had given their favorable opinions for the master plan, despite the minority opposition of the 7 municipalities. Accordingly, in April 2019, the Minister of Infrastructure and Transport ratified the outcome of the Conference of Services by issuing the decree law that gave the green light to start the works. However, the whole project suffered a setback when in May 2019, the Regional Administrative Court of Tuscany rendered its ruling upholding the challenge submitted by the 7 municipalities and, accordingly, annulling the EIA decree law. The Regional Administrative Court found that the environmental asset conducted by the Ministry of Environment was not sufficiently exhaustive. Consequently, the Minister of Infrastructure and Transport had to suspend its decree law approving the master plan, while the region of Tuscany, the municipality of Florence, and Toscana Aeroporti appealed the ruling to the Council of State, the highest administrative court in Italy. In February 2020, the Council of State dismissed the appeal of Toscana Aeroporti against the decision of the Regional Administrative Court blocking the expansion of Florence Airport. So Italy's highest administrative court rejected once and for all the expansion of Florence Airport. Reactions to the administrative court's rulings. Bewildered by the ruling of the Regional Administrative Court that quashed the EIA decree law, Toscana Aeroporti issued a press release criticizing its contents. To the company's surprise, the administrative judge completely overturned the assessment given by the National Ministerial Commission of Experts, supported and endorsed by the competent ministers of 3 different national governments, Renzi, Gentiloni, and Conti, regarding the sustainability of the technical documentation to demonstrate the lack of negative impacts on the environment. According to the Regional Administrative Court, the administration should have requested further details about the project before issuing the relevant EIA decree law. The competent administration instead concluded wrongly, according to the administrative judge, that the assessment had been thorough and complete. Indeed, the Department of Environmental Assessment of the Ministry of Environment informed the Italian Civil Aviation Authority that it reached the following conclusion. The planning documentation in the procedures archives may be regarded as adequate for the purposes of environmental impact assessment rules. The company, Toscana Aeroporti, emphasized that it was not Toscana Aeroporti that came to the conclusion that the details of the project were sufficiently adequate for obtaining a favorable environmental impact assessment. It was the competent technical departments of the ministry that came to that conclusion. Toscana Aeroporti affirmed that it did everything it was asked to in the course of the administrative procedure. Moreover, the company complained about the arbitrariness of the judgment. Potential arbitrations. With this scenario at hand, the foreign investors in Florence Airport may resort to an investment arbitration to seek compensation for the damages suffered. Toscana Aeroporti's largest shareholders are indirectly Argentinian and Emirati investors. Corporación America's main shareholder is the Argentinian mogul, Mr. Yernikian, while Matar Holdings 2 BV is a Dutch-registered company controlled by the Emirati Investment Corporation of Dubai. Both Argentina and the United Arab Emirates have a bilateral investment treaty, or BIT, in force with Italy. Both shareholders meet the definition of qualified investors under the legal instruments in question. Mr. Yernikian as an Argentinian citizen pursuant to Article 1(2)(a) of the Argentina-Italy BIT, where the UAE-Italy BIT specifically protects also state-owned entities, such as the Sovereign Wealth Fund of Dubai at Article 1(2). The shares in Toscana Aeroporti indirectly owned by Mr. Yernikian's and Investment Corporation of Dubai meet the definition of a qualified investment as per Article 1(b) of both BITs. Accordingly, both foreign shareholders could avail themselves of the protection under the corresponding BITs made effective through the investor-state arbitration contemplated in both treaties. Article 2 of both BITs provides for a fair and equitable treatment that shall be accorded to the foreign investors of the other contracting party. The core function of the fair and equitable treatment is to protect the legitimate expectations of foreign investors with respect to their investments in the host country. This is achieved by creating a stable, constant, transparent, and predictable legal framework directed at promoting foreign investments. Only this way foreign investors can plan and operate their investments with due anticipation and foresight. Admittedly, Italian administrative courts' rulings have frustrated Mr. Yernikian's and Investment Corporation of Dubai's legitimate expectations of doubling up the passenger flow, and accordingly, the revenue of their asset. Arguably, those frustrated legitimate expectations have been built up on various approvals by the local and central administration. 3 different ministers over a period of 3 years and 3 consecutive governments have endorsed the investors' project to increase the airport's capacity. Consequently, the Italian state has fully backed up investors' legitimate expectations with respect to their qualified investment. In the final analysis, either the administrative courts arbitrarily came to the wrong conclusion because the administration had sufficient details about the project to issue the environmental impact assessment, or the administrative courts were correct because the administration negligently did not request further details about the project before issuing the environmental impact assessment. In both events, it is the Italian state that first encouraged and then let down investors' legitimate expectations by failing to ensure a favorable, stable, and predictable legal framework for the investment at hand. Therefore, Italy could be held liable for breaching its fair and equitable treatment obligation before the arbitral tribunals constituted under the Italy-Argentina BIT and the Italy-UAE BIT. Conclusion. In light of the rulings of the Italian administrative courts rejecting once and for all the execution of the master plan to expand Florence Airport, an investment arbitral tribunal may realistically award damages to the Argentinian and Emirati investors for several hundred million euros. Indeed, since Florence Airport is an ongoing business already generating revenue, the arbitral tribunal will most likely resort to the discounted cash flow method to calculate Toscana Aeroporti's future lost income, which would have doubled up had the expansion been approved, until 2043, the year in which the concession to operate Florence Airport will expire. This means that the foreign investors may put forward a multi-million euro compensation claim, or they may leverage this claim to find a mutually beneficial agreement with Italy. Bottega di Bella, empowering your international rights.